kauli ya awali iliyosema tukiwa na kosa la kunajisi na kubaka kinyume cha sheria, mnamo tukiwa na kosa la kunajisi na kubaka kinyume cha sheria, mnamo kati ya tarehe 17 mwezi 3 of 2022, Alex Maina Kochovo
So we are quite apprehensive that Your Honor, if they are released, the public response to the release will not be in the interest of the said public order, peace and security. There is a danger to their lives. The public where they live, because even where they come from, their family members and the victim, they're still reeling from the pain, they're still mourning caused by this gruesome act. So that release will not be good for them. There is a likelihood that they can be harmed.
In the best interest of the minors, and also as much as we are trying to balance the rights of the accused person and those of the complainant, the best interest of the minors prevail in this situation. And also, since they are presumed innocent until proven guilty, theirs has also been considered, since the public is at rage, and if they are released to the public, they might be harmed, Your Honor. And that with regard to the state of the minor, Sagini, he's being supported by specialists to at least maybe overcome the trauma, which I believe will really take quite a while.
The prosecution shall satisfy the court on a balance of probabilities of existence of compelling reasons that justify the denial of bond. The prosecution therefore must state the reasons that in its view should persuade the court to deny the accused person's bail, which include that the accused person is likely to fail to attend court, that is likely to commit or abet the commission of a serious offense, the accused person is likely to endanger the safety of victims, individuals, or the public, that is likely to interfere with witnesses or evidence, that is likely to endanger security, and that it is in the public interest to detain the accused person in custody. The application before me is against bail supported by the affidavit of number 110667 PC David Kamau of DCI Marani Sub-County, sworn on 23rd of December this year. It explains the circumstances of the victim's harrowing attack, that the 3-year-old boy's eyes were gouged out, allegedly by the 3 accused persons herein. He narrates that the pain of the incident has not subsided among the victim's family, as well as the members of the public who are outraged by the incident. The prosecution therefore sets down 2 grounds as compelling reasons for denial of bond. 1, that there is likelihood of interference of witnesses, most of whom are said to be related to the accused person's hearing, whose identities will be known upon supply of statements, and as such, their release will raise fear, anxiety, and intimidation of witnesses. And 2, that it will be good for public order, peace, and security that the 3 be remanded for now, pending trial. This is because the ground is said to be still volatile, and there is public outrage and anger. Should they be released, their lives will therefore be endangered. The application is supported by counsels in court, Ms. Nduhukire, watching brief for the victim and appearing on behalf of LSK, Mr. Murara, learned counsel, appearing on behalf of the county attorney, Kisii County government as an interested party, Ms. Biaki, appearing for the victim and also holding brief for Mr. Nyamurongi for Sitam Church. The application is not opposed by the first and third accused persons. The second accused person, however, opposes the application and prays to be admitted to bail. In determination on the first issue of possibility of witness interference, the state is apprehensive that the witnesses who are related to the accused persons herein are likely to be subjected to fear, anxiety, intimidation, and therefore, should the accused persons be released, fear, anxiety, and intimidation should the accused persons herein be released. On this ground, the court makes reference to the authority in Republic versus Jackton Mayende and 3 others, where it was held that in all civilized systems of court, interference with witnesses is a highly potent ground on which the accused person may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either to give or not to give evidence or to give skewed evidence, amount to interference with witnesses. The court also in Republic versus Dwight, Sagaray, and 3 others held that for the prosecution to succeed in persuading the court on this criteria, it must place before the court material which demonstrates actual or perceived interference. It must show that the court, for example, the existence of a threat or threats to witnesses, indirect, incriminating communication between the accused and the witnesses, or a close familial relationship between the accused person and the witnesses, amongst others.